Shannon, you can put us on.
Okay.
Good morning, gentlemen. Gibson versus Wagner.
Good morning, Judge. I'm Tom Blasky. I represent the plaintiff.
Good morning, Your Honor. Jeff Hingeveld on behalf of the defendants.
And Mr. Blasky, I believe this is your motion.
It is, Judge. In order to really understand this motion, you need to understand a little bit of background about the case which gives rise to it and which supports it. I have the privilege.
Mr. Blasky, I presided over that jury trial.
I had forgotten that. One of the vagaries of working at home is that I'm limited with my file. So I will skip over that part of my argument. Judge, this legal malpractice case argues that that case over which you presided never should have been brought. And critical to the merit of this case is the decision-making about whether or not to bring that case. We have one set of allegations about that decision-making. Mr. Hengeveld's client, in fairness, has another. Mr. Hengeveld's client claims that there were a series of conversations and that he has documents to support those conversations between him and Mr. Gibson about whether or not to bring the case. Mr. Gibson denies in large part that those conversations occurred and also denies the substance that Mr. Wagner has claimed by his answer affirmative defenses and interrogatory answers was in those conversations. Mr. Wagner has produced several thousand pages of file. This motion asks him to go through those files and to pull out conversation by conversation, which he claims happened, those documents which he believes confirm or support either the happening of the conversation or its substance. I've not, even though we are some ways into this case and on a timeline, taken Mr. Wagner's deposition yet, because I want those documents organized that way before we do so. We have asked him to organize them in that way so that in these days of Zoom, I have a fair chance of looking at the documents, and then if I have them, asking him follow-up questions about them. I don't have a fair chance to do that if I have several thousand pages stacked up and he says, well, it's there in your file. It's there in those pages. I've looked in those pages and I don't find what he says is there. But in fairness to him, I am entitled and want to see the evidence that he claims to have in writing, that he claims he will be able to present if we ever try this case, of what he says the facts are. My effort here is to ask him to extract from his files, for these reasons, the supporting paper. I don't think that's an unreasonable or an appropriate request. Mr. Hengeveld is a great lawyer and a fine gentleman, has disagreed with me. And that's why we're here today.
Well, I looked at the discovery responses, and granted, he does, in a general way, refer to his entire file. But in answer to each specific interrogatory, look at number one, the last sentence. Mr. Wagner memorialized this particular conversation with Mr. Gibson in his time entries dated September 4, 2014 and September 5, 2014. I mean, how could he be any more specific than that?
All I'm asking him to do in that one is show me the time entries.
Your Honor, we produced the invoices. Plus, if you look at number 3, I by bait stamp number also identify a specific email in which Mr. Wagner memorialized his advice to Mr. Gibson. And again,
Do the time entries on the invoice have bait stamp numbers on them?
yes, Your Honor.
Any reason you can't provide Mr. Blasky with those bait stamp numbers?
Sure, I'll be happy to provide the bait stamp numbers for those invoices.
Similarly, with the response to number 2, there's a reference to time entry October 10, 2014. Any reason you can't provide that bait stamp number?
No, Your Honor, I will do that. And you'll see that these are pretty consistent with regard to the invoice references. So I'm happy to provide the bait stamp number for the invoice reference.
Judge, if there are any documents that are referred to, and Mr. Hengeveld agrees to provide me the bait stamp numbers of those documents, then I don't need any more relief from the court today.
Then that's what we'll do. Mr. Hengeveld, if you could please supplement for those responses that did not include the bait stamp number, indicate that. And I think we should be good.
Understood.
I will do so, Your Honor.
I think so, Judge. Judge, may I raise a scheduling matter with you?
Certainly.
Mr. Hengeveld has filed a motion for summary disposition, which of course is right, and I'm not objecting to it. But because of this issue and because of these days of Zoom and virus and all of that, I am wondering if we can have some relief for dispositive motion practice in this case, so that we may have Mr. Wagner's deposition taken and transcribed and available before I have to begin to draft my response to his motion. I understand from some of your colleagues, Judge, that Jackson County has been very prudent about the virus and that we may very well see some trials in mid to late 2021. All of us who do this work regularly are anxious to have some, but we also respect the power of the virus and the need for public safety and health. So all I'm getting at is I don't think that giving us some slack on your scheduling order will affect any trial date.
Mr. Hengeveld?
I have no objection, and I told Mr. Blasky that I filed the motion for summary just so that I was sure that I complied with the hearing date. The hearing date right now is December 28th cutoff. So I just wanted to make sure that I had that motion on file in plenty of time before the holidays and your hearing dates filled up. So that's why I filed the motion. I have no problem adjourning the hearing to allow Mr. Blasky to take the deposition and get whatever evidence he can to respond.
All right. The last word I got from our chief judge is don't expect to be doing any jury trials until sometime in February at the earliest. And I know we're all hopeful that this Pfizer vaccine will be as effective as they are claiming it's been in the trials. But disseminating the vaccine and how quickly it's going to impact the spread of COVID is anybody's guess. Assuming we are able to start doing jury trials in February, if we're doing them somewhat remotely, in the sense we're picking a jury at a remote location where we can effectively socially distance prospective jurors, the criminal cases are going to get priority. Civil jury trials are going to have to wait, and probably mid 2021 would be a good estimate as to when we're really going to see things rolling. And obviously we're going to have a backlog. I have to tell you candidly, I am looking forward to hearing about the strategy for not digging up at least one barrel for this jury trial, because that was exactly the point that was hammered home by the defense attorney. Relying on dying declarations and ground radar in a place that obviously had lots of buried metal items because it had been an auto salvage yard for years, is exactly what the jury, I mean, we talked to them afterwards. That's exactly what they were, show us the barrel.
And on that point though, Judge, my client is a very sophisticated lawyer, understood what the defenses were going to be, put it in an email before the lawsuit was even filed, explaining these will be the defenses, that you have to prove your case. You have to prove the barrels are there, and you have to prove that there's contamination. But there's risk in doing so. There's risk if you puncture a barrel and you exacerbate that contamination. There's risk that the MDEQ and EPA would come after you, and these remediation plans are horribly burdensome and costly. And so there was a full explanation to Mr. Gibson about this, and they went in kind of eyes wide open to the trial. So that's why I think, Your Honor, I will be happy to explain, and I'm sure you'll see in the motion that I filed that there is an explanation of why it's not a breach.
Judge, this may not be the time and place for it, but you imagine, knowing me as you do, because of my appearances in your courtroom before, I have a lot to say about that.
I'm certain of that.
Thank you for your time this morning, Judge.
Well, did we
You're welcome, gentlemen.
Did we resolve the scheduling issue?
Yeah, even if it runs afoul of the current scheduling order, I have no problem. We're going to have to move those dates anyway.
Okay, no problem.
Do you even have a trial date currently?
I don't recall that we do, but I may be.
I told Patty, who is my secretary for the civil matters, I said, don't bother rescheduling these trial dates that have come and gone. It's just a lot of extra work to do that. And granted, Scale likes me to have a next action on the docket. I'm not going to put somebody through a bunch of extra work only to have to move them again and again until we know for sure we have realistic dates.
That makes a lot of sense.
Okay.
We like to get those scheduling dates because it reassures us that you still love us, Judge. But other than that, we're content with how it's going.
Be assured of my unending love.
Thank you, Judge.
So I will. I will. Do you want me to send a notice saying that the hearing is adjourned to a date to be determined? Would that
works? That works just fine.
All right. Thank you.
All right. Thank you, gentlemen. Have a good day.
Good to see you, Tom.
Bye-bye.
Bye-bye.